Welcome. Grab your favorite morning beverage and join us for Morning Cannolis with Jim Santel.
You don't know me, but I'm your brother.
Sampling the news desserts of the week, here is your host, Jim Santel.
Good morning. This is Morning Cannolis, and my name is Jim Santel. Thank you so much for joining me once again this morning. It is a bright and beautiful morning in downtown Waukesha throughout the state of Wisconsin, and it is October 1st, the first day of the new month. Looking forward this morning to 2 hours, as always, jam-packed with lots of information, perspectives, and reviews of the important stories in law, in government, and the aspiration for justice in America. Thank you once again for joining me this morning on Morning Cannolis. We're here in downtown Waukesha, the studios of WAUK. That's 540 AM, 101 FM, The Shah. And I am joined in the studio this morning by my ever-faithful producer, Calvin, who will be taking our phone calls and talking with you throughout the morning about some very important issues. I'll chat about the syllabus in just one moment or so. Taking those phone calls, Calvin managing those at 844-967-2789, 844-967-2789 throughout our 2 hours this morning here on Morning Cannolis. What is our syllabus for this morning? What's our agenda of discussion of those important issues in law, in government, and justice? Well, we've got a lot to cover this morning after our traditional review of what happened today in history on October 1, our historical looking back, and celebrating today a very important birthday, an anniversary of a birth in American history, which we will also get to in just a few moments here. I'm going to spend a little bit of time following up on the significant events having to do with the investigation of the search and seizure of Mar-a-Lago, the former president's residence and home and office in South Florida. We'll chat about what happened just this past week and as late as yesterday afternoon and evening with respect to the U.S. Department of Justice and lawyers for the former president, and at least 2 federal judges now involved in this matter in addition to the 11th Circuit Court of Appeals. We'll chat about that in just a moment or so. Then we're going to follow up later this hour on our second tranche, if you will, about pardons in America. Pardons, what those are all about. Significant again because once again in the news just this past week and in news in recent times, usually talked about at the end of a presidential administration. We're chatting about it now because it's once again surfacing in connection with at least 2 important stories, which we'll also chat about. And then finally, this hour and into next hour, we're going to be starting on this first Saturday in October to talk about the first Monday in October, and that is the initiation of the new term of the United States Supreme Court in Washington, D.C. They reconvene this coming Monday to entertain argument on what is already about a 30-case docket. We're going to spend some time virtually every morning throughout the next several months talking about the major cases that have been argued during the course of the previous week, and then also looking forward to future cases. As I said, about 30 or so already on their docket, anticipating about 30 more are going to be reviewed by the United States Supreme Court. Important issues. We're going to begin to chat about that important tradition of the United States Supreme Court hearing oral argument on the important issues of our time, certainly last term and again this term, focusing on some of the very important cases that are yet to come on the docket of the United States Supreme Court. Again, this is Morning Cannolis. Thank you so much for joining us. Let us talk about what has happened and what is happening on October 1 in the history of our nation and also bringing us together today. It is the 274th day of the calendar year. 91 days left in this calendar year. What happened in October 1 in the history, principally of our nation, but also our world. 1868, on this day was the day that Louisa May Alcott first gathered national attention with her publication of Little Women, today on 1868. 1949, a huge day in international history that reverberates to this day. Mao Zedong, at that day, October 1, 1949, became the head of the People's Republic of China, proclaiming himself the leader of that huge communist nation, again, in the news virtually every day since that time. 1950, 1 year later, South Korean troops crossed the 30th parallel into North Korea. The continuation, the start, the initial events in the Korean conflict. 1950, on October 1, this day in history. 1958, about 8 years later, NASA began its operations that, of course, continue to this day. NASA in Florida, continuing to this day in connection with a number of different outreach, not only going back to the moon one day, but also exploring our universe. 1962, a very important day in civil rights history in America. We talked last week on September 24th about the significant event that happened in Little Rock, Arkansas, the decision by then President Eisenhower to integrate the schools there, premised upon a Board of Education, Brown versus Board of Education, the integration, the forced integration, when there was opposition to the entry of 9 students into the high school there. Today is the anniversary in 1962 of another major event, also involving integration of our schools, effectively putting in place the attempt, at least, to put in place the all-important propositions and the notion that separate education, separate in virtually every area of our life, is inherently unequal, and ensuring that everyone of all colors, races, national origins have access to education. 1962, on October 1, was a day that 2 people died. 75 were injured in rioting following the admission of James Meredith. James Meredith, the University of Mississippi. You can go there to that campus to this day and see a commemoration, if you will, an observation of that horrific event in our history on this day. As a result of that, John F. Kennedy, following Eisenhower in the presidency, sent about 3,000 troops to ensure the integration process would proceed in Mississippi in the wake of that event on October 1, 1962. 1971, also in the South, today was the day that Walt Disney World opened. 1975, another significant event in the world of entertainment and sports. Muhammad Ali retained his World Heavyweight Championship, defeating Joe Frazier, and yes, the Thrilla in Manila. That was 1975. 1988 and 1998, 2 important days in Russian history, international history as well. Mikhail Gorbachev, who we know just died very recently, became the chairman of the presidium of the Supreme Soviet. He had been in charge of the Soviet Union since about 1985, consolidating his power on this day. As we know, he continued in that position until 1991. He was the last leader of what we knew at that time and still know to this day as the Soviet Union. Mikhail Gorbachev in 1988, consolidating his power. 1998, a name in international and national history as well there in Russia. Vladimir Putin became a member of the Security Council of that Russian Federation on this day in 1998. And of course, as you know, as late as yesterday and this morning, continues to grab world headlines, this time for not only advancing and perpetuating the war in Ukraine, but also annexing some of the eastern provinces there, contrary to the directions and the responses not only of the United Nations, but of every civilized nation around the nation. 2013 was the day on October 1 when the federal government shut down. I was a U.S. attorney at the time, and there was a shutdown. We literally sent people home. Why? Because the United States Congress had not passed a budget to ensure the continued operation of all government operations, including those of the United States Department of Justice, and political disagreements over spending at the time basically brought virtually all services of the government to a halt on this day in 2013, a problem we still have as the Congress, even to this day, wrestles with budgets and is about to pass a continuing resolution to keep us afloat until December. Nonetheless, a continuing issue. 2015, October 1 was the day, a huge mudslide outside of Guatemala City, 131 people dead, 300 missing at the time, a huge event there. And finally, a major birthday celebrated today in America. October 1 of 1924. We're celebrating today the birthday of the first American president who was born in a hospital. The first American president born in a hospital. His name, James Earl Carter. Jimmy Carter, our 39th president of the United States of America, one-term president. Still a huge legacy in America, including the Carter Center, up for about 40 years now, operating not only in this country, of course, but around the world to promote peace and security in our times. President Jimmy Carter today celebrating his 98th birthday. Reports that he is in Plains, Georgia, where he has been. That is his home, of course, with Rosalind, who is a spry 95. And the two of them, with family and friends, are celebrating today. In addition to getting together and talking about the past, also looking to the future. The president also looking forward to viewing one of his great pastimes in America, of course, and his as well, the Atlanta Braves today, and that a part of his birthday. Jimmy Carter, of course, suffering from cancer back in 2015, a huge fall in 2019, continues to this day to be well, and we wish him well on this birthday day, October 1, way back in 1924. Jimmy Carter born this day. Reminder to all of you that all of these programs, including this, our 16th program, our 4th month on the air here, Morning Cannolis. All of them are accessible to you at WAUKradio.com, also bullfowlsradio.com. You look at the schedule on the top. You can click that and find the show, Morning Cannolis. You can also find it on Spotify and Apple Podcasts. Those are always available. We post these shows virtually within about 24 hours or so after the program itself airs live. Also repeated, as you know, on Sunday morning. So tomorrow morning, this show will be repeated in the same time slot. We've also provided you in those settings with descriptions of the shows. So if you want to go back and take a look at what we've talked about in the past, you can do just that by, again, going to WAUKradio.com, bullfallsradio.com as well, Spotify, Apple Podcasts, other things. Look for Morning Cannolis and stay with us. Stay with us this morning for our 2-hour program today, live, coming from the studios of WAUK Waukesha. We're taking your phone calls. Calvin will administer those and get you into our conversation. That phone number is 844-967-2789. I promised at the start here that we'd do a little bit of an update on issues that we have chatted about before. Very important issue having to do with the continuing investigation by the United States Department of Justice of these matters having to do with the search and seizure of properties in South Florida. And we're going to talk more about that right after the break here as we head into the next segment here on Morning Cannolis here in Waukesha. Join us. Stay with us for that discussion. This is Morning Cannolis. We're talking again, as we always do in this period, Saturday mornings at the studios of WAUK Waukesha, the Shaw, in downtown Waukesha, about law, government, and the aspiration for justice in America. From time to time, Calvin and I actually do have real live cannolis. Don's show just before this, of course, this week in Waukesha, shared some cannolis with him and his guest, and we've got cannolis here again this morning during this actual program. So we actually do enjoy that and continue to eat those as we talk about these important issues in the history of our nation. I promised right before the break that we would do a little bit of an update on one of the significant issues that continues to get the focus appropriately of Americans and certainly our news media as well, and that is this investigation of the U.S. Department of Justice regarding the search and seizure of documents at the former president's location in Mar-a-Lago in Florida. This past Thursday, a federal judge, her name is Eileen Cannon. You know her name well. She has been overseeing the civil lawsuit that was brought by the former president to address what he felt were complaints and problems with this investigation. She is overseeing that civil lawsuit while the criminal investigation goes on. This past Thursday, she set aside a major portion of the special master's orders with respect to the management of these documents. Specifically, the special master, whose name is Raymond Dearie, he's a former federal judge overseeing this process, appointed by Judge Cannon. He had asked the attorneys for former President Trump to certify the accuracy, if you will, of the FBI's inventory of the property that was seized in early August 8th. And as a result of that, the presiding judge, Eileen Cannon, issued a new order, a 6-page order, just on Thursday, that accomplished some significant changes in what Judge Dearie, in his oversight of this matter, had directed. What happened specifically? Well, Judge Dearie had requested that Donald Trump's lawyers certify by yesterday the accuracy of the inventory of that search and seizure in early August, and indicate whether there was anything in that listing, that inventory of those documents, that agents had not in fact taken from Mar-a-Lago. This in the wake of the continuing allegations in the public, perhaps not so much in court, but certainly the public, that there had been documents planted at Mar-a-Lago during the course of that search. And basically, Judge Dearie was putting Mr. Trump, the former president, and his lawyers kind of to their proof. If they acknowledged that the FBI had found some sensitive documents, obviously that admission might be significant in any future actions involving the president and others. And beyond that, the former president also repeatedly accused the FBI of planting this evidence, which was the principal focus of the special master's attempt to get to the bottom of what it is exactly that the complaint about the seizure was focusing on. And again, that certification that Judge Dearie would have requested of the Trump lawyers was either going to be to disavow those claims or repeat them in court, where they plainly would have to face some professional consequences if indeed those representations were not true. So this past Thursday, Judge Cannon sided with the former president and eliminated that stipulation about the inventory, and she said that requirement to come forward and explain their position was not contemplated by her previous order. I would offer that if you go back and take a look at her initial order, it does just the opposite, and indeed that Judge Dearie was doing precisely what Judge Cannon had directed him to do. Nonetheless, a reversal this past week by the presiding judge. And second, also a matter involving the interrelationship between Judge Dearie and the presiding federal judge, Judge Eileen Cannon. The Federal Appeals Court, as you know, last week, the week before, had always also entered into this fray about this classification issue, whether or not the Department of Justice could take a look at, review about 100 classified documents, indicated that, yes, indeed, the government can go ahead and do that, overruling Judge Cannon, who had said, no, all that's got to be a part of this special master review. But in that connection, and in the wake of that, Judge Dearie had also directed the former president's legal team to sort out any documents over which he intended to assert this thing called executive privilege. And he said, I want them in two categories. I want the privilege that would shield White House information from disclosure to people outside the executive branch. Give me one list that says that. And then another list that would purportedly shield such information from review within the executive branch. We was asking them specifically to give me some sense of what this executive branch, this executive privilege issue is all about. And basically, he was getting at this notion that the Justice Department is itself a part of the executive branch, and again, putting the lawyers who brought this lawsuit to the test. Well, it turns out that Judge Cannon, again, appeared on this issue, likewise, to side with the former president, and said that the lawyers for the former president only need to say whether something was subject to executive privilege, and if that was the case, to include a statement with a sufficient description, as she said, of the rationale and the scope of the assertion from which to evaluate the merits of that assertion. So basically, rescinding, if you will, the decisions made by Judge Dearie in overseeing this. And finally, she also prolonged the schedule. Judge Dearie had set a fairly brisk schedule for all of this review, all this document review back and forth, gave Mr. Trump's team a deadline of October this month to finish categorizing those materials in these tranches that he had described. But Judge Cannon said that was too fast, and so she slowed down the process and has given the former president's lawyers more time to get all this in place, again, with her amended direction. Significantly, just last night, in the wake of all of this, the United States Department of Justice back back before the 11th Circuit, back before the Court of Appeals, seeking to expedite the appeal of all of this, including the special master matters, reviewing these records, and saying that according to the filings on a record here, that all these cases would in fact be reviewed, all the files rather would be reviewed by the Department of Justice, including the 11,000 that are now sort of held by the special master. The United States Department of Justice plainly getting somewhat frustrated with this process and now asking the Court of Appeals once again to go back and affirm their legitimate opportunity, their responsibility to investigate this case. That now in front of the 11th Circuit as of just last night, as the department, again, continues to investigate all of this. Why do I raise this again? Well, a couple of broad observations. One, of course, it underscores the peculiar nature of all of this. In normal circumstances, we would not be hearing about any of this. Investigations follow in the wake of searches and sake of interviews with witnesses, those kinds of things. The reason that all of this is in the federal court and is the subject of this special master review, the appeals court, the district court in Florida, is because the former president brought this lawsuit seeking to challenge all of this. And so we're now getting all of this discussion about what would otherwise be an investigation not in the public domain, not subject to judicial review, as it is always pursued. That is not having oversight until that time comes when there are actual official charges brought. So this is very peculiar. Second, obviously indicates a rift between the judge, the presiding judge, and Judge Deary himself. After the break, we'll get back to our pardons issues. Continue with us here on Morning Cannolis, the studios of WAUK Radio. This is Morning Cannolis. My name is Jim Santel. Thank you for staying with me this morning in our first hour. Discussions about the important news of law, government, and justice in America. We're chatting this morning in our first hour about pardons. Pardons under the Constitution of the United States of America. What has been the history of pardons in America recently? Where does this come from, and why should we be focused on it on this first day in October of 2022? And then our second hour, we're going to be initiating a second major tranche, a second arc of discussion and review that is having to do with the United States Supreme Court that begins its new term, its 2022-2023 term, this coming Monday, the first Monday in October, entertaining oral arguments on the first of some 27, 28, 29 cases. It's already accepted for review. We're going to spend some time in our second hour chatting about what those cases are all about. We'll continue that discussion next week on October 8th as well. And as a routine part of our discussions here in Morning Cannolis, we will talk about the significant oral arguments of the prior week, what they tell us about what the Supreme Court may be doing in many of these areas. So stay with us for that discussion in our second hour as well. We began last week to talk about pardons. Pardons under the Constitution of the United States of America, and mentioned last week that under that Constitution, Article 2, Section 2, is the commission virtually unfettered, unchecked by other branches of government for the president to grant reprieves and pardons for offenses against the United States. There's an exception for cases involving impeachment. And that's really all the United States Constitution says about pardons. And as a result of that, a lot of the tradition, a lot of the history that's developed around it has been in the wake of the Department of Justice involvement in this process, the White House involvement. But again, with very little, if any, judicial check, any congressional check. That's the way our founding fathers prescribed it. And so, again, why are we talking about pardons in the middle of the fall of 2022? Again, traditionally, lots of pardon attention at the end of presidential terms, and we'll chat about some of those in just a few moments or so. Well, a couple of news stories once again prompt this. We know well that former President Trump, as he continues to communicate with the nation, both directly and indirectly, about matters related to January 6th, has said that if he retakes the White House in 2024, perhaps some other point down the road, he would consider granting pardons to many of, if not all, of those who were involved in the January 6th insurrection, the riot at the Capitol. More than 800 people to this day prosecuted by the U.S. Department of Justice, many of them getting sentenced for smaller times in prison, sometime getting probation, but many of them also receiving significant times in federal prison, 5, 6, 7 years, and we're going to be chatting down the road about some of that as well. So pardons back in the news for that reason, but also just this past week because Roger Stone and some information about what he did in the final days of the Trump administration. His interest in a second pardon resurfaced in the news of America. Let me back into that story by telling you a little bit more about Roger Stone and his history, and then talking more generally about pardons in our time. Roger Stone, as I suspect you all know well, longtime friend, associate of the former president. He was sentenced in February of 2020, a couple of years ago, to about 3 years in prison, a little bit more than that, in what could only be described as a politically fraught case that put the president at odds with his attorney general. Lots of back and forth on that particular prosecution. In the end, Roger Stone was convicted of 7 felony charges, including among those charges lying under oath to a congressional committee and threatening a witness whose testimony would have exposed the lies that he was perpetuating at the time. In July of 2020 and again in December of 2020, the President of the United States of America, that is Donald Trump, took 2 actions under the Constitution, properly done under the Constitution. Donald Trump commuted Mr. Stone's sentence in July, basically reduced the amount of time he had to spend in federal prison, and then pardoned him outright in December of 2020, commuting the sentence, reducing it, and then forgiving it completely as a pardon in December of 2020. A White House statement issued by the president at that time said that Roger Stone had been treated very unfairly, the words of that statement, and added that pardoning him, quote, pardoning him will help to right the injustices he faced at the hands of the Mueller investigation. And so that was the history of Roger Stone until this past week. Roger Stone, apparently at the time of the January 6th insurrection, had also sought from the former president a second pardon, indicating that indeed if he was going to be prosecuted by the U.S. Department of Justice for his involvement, whatever that may be, he has not been prosecuted to this point. We don't know about any future prosecution, but news came out that Roger Stone had sought a second pardon from President Donald Trump after the Capitol riot. According to some texts seen by various news sources, Mr. Stone had approached a fellow named David Schoen, who was an attorney who represented Donald Trump in the second impeachment trial. And Roger Stone had asked Schoen to promote his request for a pardon when he spoke to Mr. Trump. At this point, Stone said, I'd be happy if he pardoned me and at least one other person a second time. And so once again in the news about that, plainly, someone who is no longer in the presidency does not have the power to pardon. And so to this day, the only person in the United States of America who can issue pardons, who has done some of that, is the president incumbent, and that is obviously Joe Biden in the White House at this time. But all of that prompts us to look at pardons once again and think about our history and what may in fact happen. A president can pardon at any time in his, perhaps one day her, tenure in the White House. And so this, while again traditionally does happen at the end of terms, we know well that a president can do this to exercise clemency, pardon someone, basically remove the record of their prosecution from official records at any time. And for about 125 years or so, the presidents have relied on something called the Office of the Pardon Attorney. Talked about this a bit last time. Talked about the fact that was the office that had helped the president in executing his responsibilities under Section 2 of Article 2, and basically to ensure that there's consistency, that there's fairness, and most importantly, decency, right? That the rule of law is not only addressed, but also advanced in the granting of pardons, clemency, those kinds of things. It's a process by which the applications are made to the Department of Justice, sent on to the White House for consideration with recommendations about the merits, the demerits of those particular applications so that a sitting president can make those decisions. Significantly, the United States Department of Justice, under the Office of the Pardon Attorney, is also guided by a little bit, not a huge amount, but a little bit of guidance from the United States Supreme Court in a case called the United States versus Wilson. Way back in 1833, Chief Justice John Marshall, writing for a majority of the court, had said this: "A pardon is an act of grace, proceeding from the power entrusted with the execution of the laws, which exempts the individual on whom it is bestowed from the punishment the law inflicts for a crime he has committed." That's Wilson back in 1833. And again, that notion that this is an act of grace, it is not mandatory. It's not checked by any other part of government. It is an attempt by the executive branch. It is an accomplishment, if it's done by the executive branch, to do justice, to execute grace in a way that acknowledges that someone who has admitted they have committed a crime, that is implicit and explicit in accepting a pardon, that you acknowledge your criminal activity, but has done something in their life, have done something in the community to promote justice, to promote better things in our lives and livelihoods, and based upon that, there are merits or perhaps some demerits to it. This act of grace is what the United States Supreme Court has said. In addition, a case called Burdick in 1915, the Supreme Court had also said a pardon carries an imputation of guilt, an exception and a confession of it. So when Roger Stone, for example, accepts that pardon, which he did from the former president, he's acknowledging his guilt to the underlying charges, as do the other cases we're going to chat about this morning. The Supreme Court going on to say it remits punishment, it eliminates it, and condones infractions of the peace of the state. Well, that may be a bit of an overstatement. I don't know if it's condoning it, but it nonetheless removes it from the official records. Indeed, if there's a pardon granted. We're going to chat this morning about what all that means, how the Office of the Pardon Attorney is involved, and specifically we're going to talk about some historical pardons granted by former presidents, including especially former President Trump, as we think about these important issues of this time. Before we get to that, we already have a caller. Mark, thanks for calling in this morning as we're chatting about pardons in America.
Yeah, I'm just curious, is that since Roger Stone apparently threatened somebody, could his admission of guilt, even though you've got a pardon, be used in the civil case against Roger Stone if you decided, hey, this guy threatened me, it caused me, caused me harm, that I felt threatened, I felt scared and all this, and could that person actually sue Roger Stone and use his admission of guilt in accepting that pardon as evidence of his guilt and his threat against somebody?
Right. It's a great question, Mark. Thanks for that. And again, these kinds of things, they are in the public record. Pardons are officially a part of our government procedure. They're a part of the records out there. And so to the extent that there are lawsuits, if there are depositions taken inside those lawsuits, if there are future criminal prosecutions, the official records of the U.S. Department of Justice, of our government, certainly can be used. There's no doubt that Roger Stone got this pardon from the former president. And again, according to the Supreme Court, that carries with it an imputation of guilt. And to the extent that that is relevant, not only in this so-called threat case that may be percolating up again, certainly relevant. And again, good advocates, good lawyers on both sides would argue about exactly that kind of thing. So I appreciate the call very much. And that practical implication of what all of this means, why this is important in America today. Robert, thank you also for calling in this morning as we're chatting about pardons and the process under the Constitution.
Hi, good morning. Quick question. A lot of the pardons that Trump has given have been to his associates that have been involved with various felonies and crimes. And in many cases, he has a conflict of interest. Has there ever been a court case that's challenged the ability to pardon when the actual president himself is kind of a co-conspirator with some of the crimes? And if so, what was the outcome legally?
Sure. What a terrific question, because, Robert, believe it or not, in my syllabus here this morning, that's one of the points I'm going to make as we talk about many of those cases. I'm going to pull about maybe 6 or 7 of those and chat about that very issue that, Robert, you just raised so thoughtfully. The law is clear, that the Constitution is clear, and it's been interpreted this way under the law, that the president does have the unfettered right to do this. Congressional action to try to rescind a pardon will not be effective. It has not even been tried because of it. Likewise, a judicial challenge to the pardon itself is not out there. This is one of those few times in the Constitution's structure, as written by James Madison and George Mason and others, where there really is not any check at all. Having said that, however, so what that means effectively is that if the pardon is granted, for example, the Roger Stone pardon, and others that we'll talk about at your invitation this morning, none of this can be rescinded. On the other hand, an awful lot of people think that to the extent that the accomplishment of the pardon itself is a product of corruption, of obstruction of justice, of witness tampering, all kinds of things, inappropriate behavior, that underlying product, that underlying process, if you will, to get there could potentially be the focus of a criminal case, maybe a civil case, addressing the impropriety in getting there. Again, it doesn't affect the actual effect and the status of the pardon itself, but would in fact have that impact upon a review of the underlying process to get there. And so we're going to chat at that very invitation when we come back from the break, not just about Roger Stone, but about many other cases in which pardons were granted. We're going to explore that very issue of the unfettered access of the president We are back. This is Morning Cannolis, and we're chatting this morning about pardons, talking about where this authority vested in the presidency comes from in the Constitution, how it has been traditionally affected, how it's been accomplished through this Office of the Pardon Attorney, and chatting about some of the recent history involving Roger Stone. Let me add another aspect to this this morning. Let's talk about Steve Bannon a little bit as well. Mr. Bannon, as you know, was Donald Trump's former chief strategist and architect of his 2016 presidential campaign. He was charged in August of 2020 with defrauding contributors to a privately funded effort to build the border wall, the south border wall with Mexico along the border to our southern nation there. And in the wake of that, Mr. Bannon was, in fact, going to trial based upon his promise of building that wall. The allegation was that he and others, a Florida venture capitalist, has conspired to cheat hundreds of thousands of people, of some donors, into this effort by falsely promising that their money had been set aside for new sections of the wall, when in fact none of that was true. Well, while he was going to a trial on that, he was in fact the recipient of a pardon late in the administration of Donald Trump. January 19th, 2021, Steve Bannon is basically absolved of that. He, under the Constitution, Donald Trump grants him a pardon, and so that federal case goes away based upon that pardon decision. However, as we know in this situation, the New York State followed up and, in fact, has now initiated a new prosecution of Steve Bannon for much the same thing: money laundering, conspiracy, fraud, and this online scheme to raise money for the building of this wall. The state of New York, a state, has now prosecuted Steve Bannon. He was recently arraigned for those charges. Plainly, a federal pardon does not absolve you from responsibility if you're charged in a state system. Federal pardons only apply to federal prosecutions. And so Steve Bannon, again, back in criminal court, this time in the state forum of New York, even though he was previously pardoned by Donald Trump for the same kind of conduct that is out there. I'm going to chat about other cases like that where Mark, before the break, appropriately said we're concerned when a president does this with respect to his friends, his business associates, family members perhaps, and we'll chat about more of those as we continue with this discussion this morning of pardons. Before we do that, let me take Joe. Joe, you're calling in this morning. Appreciate your call, your comment or thought about pardons in America.
Well, I'm sure you're going to be getting into more of this, but I think the questions raised by Mark, the previous caller, and by Robert were really fascinating, and I had been thinking along the same lines, too. When you get into the complexities of pardons, it's been that, as you say, at the end of an administration, there's this, thoughtful examination of who is deserving of clemency. If you have a situation where Trump is if he's elected again, he said he would pardon those all 800 plus who participated in the January 6th coup. There is no careful looking at these people, each particular person, and what they did and how they contribute to the community. He is basically saying, I'm going to pardon them simply because they participated in the coup to help overturn the election to my benefit. That is, in a sense, a pardon for a quid pro quo, wouldn't you say? And not unlike saying, well, this person gave me $1 million, therefore I'm going to give him a pardon. So it seems like we are entering this territory with Mr. Trump, again, bending the norms into, I would say, if not immoral and unethical, possibly illegal, except that, as you say, what is written about pardons is there's really very little check on it. So I was curious if you consider this case of Trump saying 800 people, the only thing that ties them together is that they participated in the coup, how that would be affected in the pardon situation.
Right.
So I appreciate your comments on this, and I'm sure you can unfold them over the next hour. Thanks a lot, Jim. Fascinating discussion.
Thanks so much, Joe, for calling in. As always, appreciate that. And it brings me precisely to the points we're going to chat about in the remaining moments of this hour and next as well. It really does underscore the point of our discussion last week and again this week, which is this unfettered power has got to be exercised by someone who is responsible, right? And the whole idea behind the Office of the Pardon Attorney is to address exactly what you're describing, Joe, and previous callers as well. This notion that no one should have access to the president simply because you're a friend, a business associate, you've got some particular issue. As Joe, you've just indicated, 800 people, giving them blanket pardons, not addressing their specific circumstances about why a particular person's history, their contributions to the world may justify this, but doing it simply because you think that their prosecutions were inappropriate. I would offer that even though there's very little direction, certainly not in the Constitution, very little direction out there generally, that's the kind of thing that the Office of the Pardon Attorney would recommend against doing. Just because, again, there's nothing about those cases. They're very, very fresh. They're still happening. That would suggest that these folks merit it. If there's a reason to believe that incredible injustice was done or is being done by the federal courts in managing these, imposing these sentences, that may be something different. I don't see that out there, and I think, Joe, that's your point. This quid pro quo notion, it's very troubling, absolutely. If, in fact, you're using your authority, unfettered authority, to accomplish things for your friends and associates, that's why people should be focused upon this. As I said before, arguably, you could get at the process by which this is accomplished. If someone is getting money to petition the president, that could be regarded as corruption, which could be prosecutable. But the pardon itself would remain, and that's one of the great concerns. So I think, Joe, your issues are spot on once again. And let's talk about one more of those before we go to our hour break here, and that's Paul Manafort. Got a pardon on December 23rd of 2020. Paul Manafort sentenced in 2019 to 7.5 years in prison for his role in the decade-long multi-million-dollar financial fraud scheme for his work in the former Soviet Union. Lots and lots of information there. He's 71 years old. He was released early from prison in May as a result of the coronavirus pandemic at the time, and was given home confinement. That done by the Bureau of Prisons while he was under their supervision. Donald Trump repeatedly expressed sympathy for Mr. Manafort, describing him as a brave man who had been mistreated by the special counsel's office, ultimately granting him a pardon on December 23rd of 2020. Again, to Joe's point, to the comments and points of the other callers, that kind of thing where there's no indication that there has been an injustice, and one asks aloud, what about that particular situation calls for a rectification, an expression of justice somehow, an expression of grace, as the Supreme Court has said, that warrants the imposition of a pardon here, the decision about a pardon. Nothing about that suggests that would be appropriate. And after the break here for the hour, we're going to chat about a few more of these and then go into our second discussion about Supreme Court cases. So stay with us. Stay with us as we go into our final hour here on Morning Cannolis. We're chatting about pardons, and as always, taking your questions at 844-967-2789.
Welcome. Grab your favorite morning beverage and join us for Morning Cannolis with Jim Santel.
You don't know me, but I'm your brother.
Sampling the news desserts of the week, here is your host, Jim Santel.
Good morning once again. This is Jim Santel. This is Morning Cannolis. Thank you for joining me for this second hour of our Saturday morning discussion here, talking about law, government, justice in America. Our topics are serious this morning, as they always are. We're going to be finishing up our discussion in the first moments of this second hour about pardons in America, talking about some of the recent history of a former president named Donald Trump. And then in our second hour, this second hour together this morning, we're going to move to the United States Supreme Court as it begins its new term, 2022-2023, in just a couple of days, the first Monday in October. I want to begin to chat about some of the significant cases in front of the United States Supreme Court, including 2 or 3 they're going to be reviewing as soon as this coming Monday. But before we get to that, let's get back to our discussion about pardons in America, pardons under the Constitution of the United States of America. Some great callers in our first hour who underscored this fundamental notion that the Supreme Court has also established, which is pardons are acts of grace. There are situations where an individual who acknowledges that she or he has committed a crime that is implicit in the acceptance of a pardon comes forward and says, you know what, I have done something in my life. I have engaged in conduct that, while it does not remove the history of my conduct, my criminal behavior, nonetheless it warrants, out of justice, out of grace, that my pardon to be removed from my official records. Doesn't remove history, of course, but does in fact accomplish this grace that the Supreme Court talks about routinely. And so reviewing some of those that the former president, Donald Trump, granted throughout his term, and especially near the end of his term, right before he left office in January of 2021. Here's another one, Charles Kushner. Kushner, if that name sounds familiar, it does, because Charles Kushner, who is in his mid to late 60s or so, the father-in-law of the president's older daughter, Ivanka, the father of a fellow named Jared Kushner, a senior advisor to the president throughout his term. Mr. Kushner was found guilty, actually pleaded guilty in 2004 to 16 counts of tax evasion, a single count of retaliating against a federal witness, and one of lying to the Federal Elections Commission. He served 2 years in prison before being released in 2006. That prison term, that sentence, was unmistakably, according to Jared, according to Ivanka, others, a real searing event in the life of the Kushner family. Significantly, this witness tampering matter, which was also a part of his conviction for which Charles Kushner did serve time in federal prison, goes like this. He was accused of retaliating against his brother-in-law, whose wife, Mr. Kushner's sister, was cooperating with officials in this campaign finance investigation. Following all that, Mr. Kushner was accused of videotaping his brother-in-law with a prostitute and then sending it to his sister. This man then came forward, and during the course of the Trump administration, his son, then working for the president, effectively during the course of that administration, the Trump administration, Donald Trump grants him a pardon for his previous conviction, and obviously, and again, not removing that from the history of our nation, but nonetheless removing the official records of that pardon. Interestingly, Chris Christie, who at the time of the prosecution of Charles Kushner, was the U.S. attorney in New Jersey, was the one who prosecuted Charles Kushner for that case, bringing along with it an awful lot of animosity between Chris Christie and the Kushner family. One of many, many pardons granted by former President Trump, this one to a relative, if you will, again, raising the question about whether or not this is a proper exercise of the grace and of the authority vested in the presidency to accomplish justice in situations where it really does have to be accomplished. A couple of others that also, like Paul Manafort, come out of the investigation by the former special counsel into Russia and obstruction of justice. You may recall the names George Papadopoulos and Alexander van der Zwaan. Both of them received pardons by former President Trump. Papadopoulos, who was his former policy advisor in the 2016 campaign, he pleaded guilty to making false statements to federal officials as a part of the investigation by Robert Mueller, the special counsel. Did that in 2017. You may recall well in Wisconsin here that Mr. Papadopoulos did in fact serve 12 days in jail right here in the state of Wisconsin in our federal prison for lying to the FBI about his contacts with Russian intermediaries during that 2016 presidential race. Later published a book portraying himself as a victim of the deep state plot to bring down President Trump. George Papadopoulos, one of the people that President Trump then pardoned for that criminal conduct. Also, this lawyer named Alexander van der Zwaan, probably not one of the major players, major figures in the investigation by Robert Mueller, but nonetheless sentenced in 2018, April of 2018, to 30 days in prison, again, for lying to investigators for the special counsel's office, again, investigating the Russian interference in the 2016 presidential election. Alexander van der Zwaan also the recipient of a pardon based upon the president's exercise of authority under the Constitution. So those also out there. Let's talk about a couple of others before we move on to other subjects this morning. Michael Flynn, very much in the news to this day and certainly throughout the Trump administration. Michael Flynn received a pardon on November 25th of 2020. You recall him well, a former national security advisor in the first days of the Trump administration. Michael Flynn twice pled guilty to lying to the FBI about conversations with a Russian diplomat. A lot of story there, lots of history there. Prosecution by the Attorney General. His name was William Barr, you may recall well. That was shut down by the Department of Justice. A lot of litigation about the entry of pleas of guilty by Michael Flynn in a federal district court, went up to the Court of Appeals in the District of Columbia. Lots and lots of prosecution inside that prosecution for lying about his involvement with this Russian diplomat. In the end, the White House officials, including the president, said he should never been prosecuted. The president's action, according to Donald Trump, brought to an end, quote, the relentless partisan pursuit of an innocent man. Again, former national security advisor, plainly a political advisor, given a pardon by former President Trump in November of 2020, several months before Donald Trump left the White House. A couple of others who are also in the list of the recipients of pardons by former President Trump. You may recall a fellow named Joe Arpaio, elected sheriff of Maricopa County, Arizona, 5 times elected before he was ultimately charged but with criminal contempt for defying a court order. The United States Department of Justice, through its Civil Rights Division, had brought actions to try to remedy some of the civil rights violations accomplished by Joe Arpaio as the sheriff in connection with his management of prisoners in his duty and responsibility as the sheriff of Maricopa County. He was an anti-immigration crusader, called himself America's toughest sheriff, and was actually the first pardon of Donald Trump's presidency, a very divisive figure in Arizona, throughout the United States as well. And he defied a court order that told him to stop detaining people solely on the suspicion that they were undocumented immigrants. He was pardoned by Donald Trump less than a month after he was found guilty for being in contempt of the court order. That one of the many pardons issued by former President Trump. Rod Blagojevich. Remember Rod Blagojevich? Rod Blagojevich, former governor of Illinois, was sentenced in 2011 to 14 years in prison for trying to sell or trade to the highest bidder, basically, the Senate seat that was once occupied by a fellow named Barack Obama. Mr. Obama plainly vacated that seat when he was elected president in 2016. Rod Blagojevich, under the law, then obliged to appoint someone to serve the remainder of that term. And while Mr. Blagojevich was waiting trial, he was a contestant on The Celebrity Apprentice, which was, of course, Donald Trump's NBC reality TV series. He was fired fired at the end of that fourth episode, if you will, of that program. Rod Blagojevich, the recipient of a commutation, a reduction of his sentence of 14 years on February 18th of 2020 by former President Donald Trump. And then let's do a couple more and then move on to other issues this morning. Scooter Libby. Remember Scooter Libby, Vice President Dick Cheney's top advisor. He was convicted in 2007 of 4 felony counts, perjury, obstruction of justice, in connection with his disclosure of the identity of a former CIA officer. Her name was Valerie Plame. Remember this story? In any event, Mr. Trump, when he became President of the United States of America, looked at his application. Mr. Libby had maintained his innocence for many years. Mr. Trump portrayed Mr. Libby as a victim of an unfair prosecution, and ultimately, Donald Trump gives him a pardon on April 13th of 2018. And finally, among this long list, not completely exposing all of these pardons granted by the former president, but Michael Milken. Remember Michael Milken? Got a pardon from Donald Trump on February 18th of 2020. Michael Milken was the billionaire junk bond king. Remember him? Well-known financier on Wall Street in the 1980s. He pled guilty in about 1990 to securities fraud and conspiracy charges, sentenced to 10 years in prison. The sentence was later reduced to about 2. We paid $600 million in fines, in penalties. He did not, in fact, like many of these others, have a pardon or a commutation application pending at the pardon office, the Office of the Pardon Attorney, meaning that, like our callers identified early on, that this decision was made without any official department involvement. And, of course, Mr. Rudolph Giuliani, who was one of the president's principal advisors, was the fellow who prosecuted Mr. Milken way back when he was U.S. Attorney. Rudy Giuliani, now in the ear of the president, advocates for this pardon. All of this to indicate that there is a reason for America to be focused upon pardons issued by any president, to determine that, again, that these are things done out of grace, acknowledging, again, that there is criminal conduct that the president is effectively forgiving by virtue of commuting a sentence or pardoning, removing the information about it completely from official records. I should note as well, in the interest of partisan balance here, that other presidents have also been on the receiving end of good criticism, legitimate criticism for pardons that seem to be inappropriate. You may recall well, way back in the end of the Clinton administration, funny Mark Rich, the king of commodities, got a controversial pardon in 2001 by President Clinton. And so all of this under the Constitution, a reason to be focused in the future about pardons in America. Come back right after the break. We're going to talk about the United States Supreme Court, its coming term, first Monday in October. We're back. This is Morning Cannolis. My name is Jim Santel, and in the remaining hour here on the WAUK, Waukesha, the Shaw, 540 AM, 101 FM, we are turning our attention now to the United States Supreme Court. The United States Supreme Court, established by Article 3 of the United States Constitution, very important in the life and livelihood of our nation. Our first programs here on Morning Cannolis back in June focused upon some of the most significant cases of the prior term of the United States Supreme Court, 2021, 2022. We talked for several programs about things like guns and abortion, environment, immigration, many other cases that were defining that court and also defining our nation. It is in that same spirit that we're initiating this morning our next arc of focus and discussion on the United States Supreme Court. Why? Because in just a couple of days, on October 3rd of 2022, the United States Supreme Court begins its next term, reviewing at this point about 27, 28, 29 cases in which it has already said it's going to take a look at the merits of them and render decisions about the various important issues, again, in front of America these days. So we're going to be initiating this morning our discussion of the United States Supreme Court. I want to talk this morning, as we will probably every single Saturday morning going forward here as the new term begins, about the important cases that were argued in the previous week. We're going to get to 2 or 3 of those at the end of this second hour here on Morning Cannolis. Before we get to that, let's do some predicate information once again in anticipation of the first Monday in October, the reinitiation of the review by the United States Supreme Court of its oral arguments in Washington, D.C. And in that connection, a very significant announcement by the Chief Justice, John Roberts, in the early part of September. Up until now, for the past couple of years, all of the arguments, although they have been accessible publicly, have not been in public. That is because of the coronavirus concerns and transmission concerns. The United States Supreme Court building has been closed to the public. The Supreme Court Justice, Chief Justice, has announced just this past month that is going to change. And so beginning on Monday now, members of the public will have access to the building. Not all the tours, not all the access to every room that previously at least was part of the tour. But if you are in Washington, D.C., beginning on Monday morning, you can stand outside and eventually get in to see some of the oral arguments in person in the actual chambers of the Supreme Court there as well. More important probably for most of us, the oral arguments are going to be live streamed. And so you can go online, you can go on radio, you can listen to many of the oral arguments coming up beginning this coming Monday. And you can also, of course, go online. I'm going to chat about some of the access points at the end of this hour and the end of every hour coming in the future sessions here, where you can get more information about all of these oral arguments. So let's talk more about where all this comes from and why it is we've got a United States Supreme Court that's making these important decisions today. Well, the Constitution, once again, as you well know, says the judicial power of our nation is vested in one Supreme Court and inferior courts as the Congress may from time to time establish. And in the Judiciary Act of 1789, our first Congress did in fact establish a Supreme Court, giving it a number of 6 justices altogether, including a Chief Justice. Significantly, that number established legislatively. The number is not in the Constitution, and so, yes, that's right, the number can and has changed. The number of justices presiding, the number of judges reviewing these cases, it has gone up to as high as 10, as low as 5 throughout our history. Justices remain in place during their term, as the Constitution says, of their good behavior. That has almost always been interpreted to mean lifetime tenure. So federal judges, all federal judges, including justices of the Supreme Court, have lifetime tenure. Thus, the significance of their appointments, the significance of appointments to courts of appeals around the nation. As we've talked before about the 11th Circuit, for example, we're right here in the 7th Circuit. Judge Eileen Cannon, who is a federal district court judge in South Florida, she also has lifetime tenure. Raymond Dearie, who is the special master in that case, he is retired, but he continues to work in that role by virtue of his prior appointment by a former president, confirmation by the Senate to that position. Some interesting statistics about the United States Supreme Court: 115 justices to this date. Only 6 of them have been women. We've got 4 retired justices who are still living. Where does this process come about? How do we get to this point where Supreme Court justices are reviewing the legitimacy of the law, decisions made by lower courts, and even by legislatures along the way? Well, way back in 1803, there was a case that was before the United States Supreme Court, and in particular before the Chief Justice at that time named John Marshall. John Marshall, a lion in the history of American jurisprudence. John Marshall came forward in this case called Marbury versus Madison and said this. He said, "An act of the legislature that is repugnant to the Constitution is void." Is void. He went on to say this: "It is emphatically the province and duty of the judicial department to say what the law is." That is the expression by the United States Supreme Court, the codification of this notion of judicial review, the doctrine that the United States Supreme Court now reviews decisions of lower courts and tells us what the law is. The judicial department is, as John Marshall described it today, we regard them as the judicial branch. And indeed, between about 1960 and 2000, that 40-year period, the United States Supreme Court found about 500 laws either constitutional in part, unconstitutional in part, or in whole. So this role of judicial review, and the rule that is established by Marbury versus Madison, that is by which a Supreme Court can in fact and does review the legitimacy of lower courts and makes determinations about them. This has been around since 1803. Marbury versus Madison itself had to do with a dispute between Thomas Jefferson and John Adams, our second president, with respect to a delivery of a commission to serve in an office as those officers were changing positions between administrations. Marbury versus Madison, to this day, a very important case in the life of our nation because it establishes what's going to happen again on Monday as the Supreme Court reconvenes. What do we know about this coming term, 2022-2023? Well, I've said a couple of times this morning, the Supreme Court has already agreed to review about 27, maybe 28, 29 cases altogether, just under 30. Likely that number will increase to about double of that during the course of the term, which will continue until next year at this time, but likely resulting in decisions being rendered by the Supreme Court in May and June of next year that are going to be significant. And those are the cases we're going to spend some time talking about this morning and then beyond. We know about those cases as they come forward. We're going to chat more about some of those cases right after the break here on Morning Cannolis. We are back for our final half hour this morning on Saturday, October 1. This is Morning Cannolis, and we're initiating this morning a brand new segment here at Morning Cannolis that we're going to be continuing with throughout the coming weeks and months. And that is focused on the United States Supreme Court this coming Monday, first Monday in October, the new term of the United States Supreme Court, about 27 or more cases already pending in front of it, a number likely to increase by 2 before this next term concludes. Anticipate many significant decisions in many, many areas in this coming term, probably May, June, maybe even July of next year. Again, very important issues having to do with, for example, race admissions, giving consideration to race in admissions for colleges and universities, Medicare, Medicaid issues, immigration, the Commerce Clause, Native American Indians, and the ways in which we manage the children of our Native American populations. Among the very important cases, there are 2 related to elections and voting. One of them has to do with something called the Independent State Legislature Doctrine, going to be reviewed by the United States Supreme Court, a case coming out of North Carolina. We're going to talk about that in a future show, but has the potential to dramatically change the way in which we remedy problems, challenges with voting in America. Who is responsible for reviewing decisions of elections commissions and of legitimate and nonpartisan poll workers, those kinds of things? An awful lot of people looking very closely at a case raising this issue of whether or not an independent state legislative doctrine should change the way in which we decide voting decisions, rules, regulations, what happens in our polls. A number of other cases. We're going to talk about 2 of them in particular that are going to be on the docket of the Supreme Court this coming week. Let me mention just very briefly that beginning as soon as Monday, October 3rd, a case in which Wisconsin actually appears. It's called Delaware versus Wisconsin and Pennsylvania. It has to do with who is responsible, which state is responsible or entitled to unclaimed or uncast checks issued by something called the Money Green Payments System. So kind of a financial case, a banking case. Supreme Court's going to be hearing argument about that case beginning on Monday. Again, Delaware versus Wisconsin and Pennsylvania. I'm going to spend most of the rest of our time this morning talking about two other cases, one in the environmental area and the other one in the voting area, the gerrymandering area. Again, coming up this coming week, one of them on Monday, October 3rd of this new term. Let's talk about it. Let's talk about this case, where it comes from, understanding that every single one of these cases, the just under 30 cases already pending before the United States Supreme Court, the others to be granted cert, which is the way of describing the Supreme Court's decision to take cases on. All these cases arise from particular disputes. It is not the case that the Supreme Court simply wakes up in the morning and says, gosh, let's figure out something about abortion or guns or environment or immigration. All of them resulting from a case and controversy that can come up from a lower federal court, can come up from a state Supreme Court. There is a bit of original jurisdiction before the United States Supreme Court, also the subject of at least one or two cases this term. All of these cases resolved by the Supreme Court ultimately by a majority vote of the justices, the 9 justices presently on the Supreme Court. And all of them, however, that we're going to talk about here on Morning Cannolis, all of them related to important issues that affect our lives and the ways in which we go about living here in the United States of America. So let's talk about, first of these, an environmental case. We know that last term, the United States Supreme Court found that the president did not have the capacity through the EPA to impose some limitations on corporations for their expelling greenhouse gases. And one of the principal themes of the term last term, and again this term, is probably going to be this focus of the Supreme Court on the extent to which government can act, and in particular the discretion, the authority of the executive branch to make decisions in areas like the environment and immigration. One of these cases has to do with the EPA, and here's how it comes about. A fellow named Michael and his spouse Chantel Sackett, S-A-C-K-E-T-T. They're planning to build a home on some property near a place called Priest Lake, Idaho, and it is near a wetlands area. They began to dump some sand and some gravel there to support that construction. And the Environmental Protection Agency came along and said, wait a minute, we're halting your work. Why? Because your lot on which you're going to build this home includes some wetlands under the Clean Water Act, and specifically that those waters the EPA maintained are subject to regulation, and you can't simply dump gravel and sand and other things in those waters. That would be a violation of the Clean Water Act. So the EPA comes in and tells the Sacketts they cannot build on this land. A dispute that's been going on for about 15 years or so in Idaho, near Priest Lake, Idaho. The Ninth Circuit Court of Appeals reviews all of this and upholds the agency decision to prevent the Sacketts from going ahead with their construction of this particular property, and noting that, as the Ninth Circuit says, jurisdiction over wetlands depends upon the existence of a significant nexus, a tie, in other words, between the wetlands in question and navigable waters in the traditional sense. The reason why that's significant is because the word navigable waters, meaning places and the waters in which you can navigate, that's the language of the Clean Water Act. And so that's how the case is brought. The case comes up from the Ninth Circuit Court of Appeals, which again upholds the EPA's authority to stop the Hacketts from building on this wetlands adjacent area. The premise of the argument advanced by the EPA is that by dumping the sand and the gravel into the tributaries, the waters that lead into Priest Lake, the larger water area in Idaho, that by doing that they're violating the Environmental Protection Agency's Clean Water Act and basically destroying the clean water in that area. Significant. This is not the first time, of course, that the Supreme Court has addressed the Clean Water Act. way back in 2006 in a case called Rapanos, Rapanos, versus the United States. The Supreme Court actually divided, could not come up with a decision. There were only 8 justices at that time deciding the case, so there was not a majority opinion, but it didn't stop members of the Supreme Court from pontificating about what the Clean Water Act means and whether or not by dumping products into a tributary, into channels, into ditches that ultimately make their way into a larger waterway, whether that is a violation of the Clean Water Act. We know, of course, that by dumping these kinds of chemicals and pollutants and other things into, say, like Lake Michigan, Lake Winnebago, those kinds of things, that would be a clear violation. What about rivers? What about tributaries, smaller tributaries, channels that go into those larger water areas? Would that be in violation of the Clean Water Act? Antonin Scalia, writing for at least several other Supreme Court justices way back in 2006 in this case called Rapanos, says that waters of the United States under the Clean Water Act, according to Justice Scalia, do not include channels through which water flows intermittently or ephemerally, or channels that periodically provide drainage for rainfall. So his view is a narrow interpretation of the Clean Water Act cannot violate it, EPA, if in fact you're dumping something into a tributary, a channel, a ditch that ultimately leads into a navigable water, a larger water flow. That's not a violation. Plainly, that's not the EPA's position. Same case way back in 2006. Justice Anthony Kennedy, likewise not on the court anymore, as we well know, but one of those 4 Supreme Court justices who's in retirement, still alive today, said just the opposite, took exception to what Justice Scalia had said, and indicated that the Clean Water Act applies if, in fact, the waters significantly affect the chemical, physical, and biological integrity of other waters, and those are understood to be navigable. And so that is the decision by the Supreme Court, frankly, not to decide the case way back in 2006 in this Rapanos matter. It's back again before the EPA in this case called Sackett. It's called Sackett versus EPA before the Supreme Court, coming up for oral argument as soon as this coming Monday. And a case that determines whether or not the EPA has the authority and the responsibility to enter into to litigate and then to enforce its rules and regulations under the Clean Water Act. Sackett versus Environmental Protection Agency coming up very, very soon, Monday, October 3rd. But when we come back after the break, we're going to talk about one other case involving gerrymandering and voting in America. Stay with us for that here on Morning Cannolis.
I'm sorry, Jim. We have 4 minutes left.
Okay. All right. Very good. So we'll continue with that discussion right now. I thought we were going to a break. We'll continue with that important discussion right now of this other case also before the United States Supreme Court. And that case is Merrill versus Mulligan. Merrill versus Mulligan. I mentioned before that the Supreme Court is taking a look at many cases this term involving the voting rights of Americans, and in particular, in this particular case called Merrill versus Mulligan, is determining something about gerrymandering. So let's go back and talk about how that plays out. In 2021, not that long ago, the Alabama legislature drew, as Wisconsin did as well, some new congressional maps. This is based upon the census done at the time. And that map that the Alabama legislature drew at the time unmistakably gave black voters much less representation in the federal House of Representatives than their population numbers would indicate. And probably there's a fair amount of agreement that is in fact the factual matter about those maps in Alabama in 2021. Basically, disenfranchising many black voters in Alabama. In particular, some of those statistics are that the overall population, the African American population in Alabama, 28% of that is African American. But under this revised districting plan adopted by the Alabama legislature in 2021, they would likely elect a candidate of their choosing in only one of the 7 congressional districts. So while wildly disproportionate with the amount of the population that is black in Alabama. And so that goes up to the Court of Appeals. And the Court of Appeals, this case in the Fifth Circuit, looks at all this and says, nope, those lines are in fact in violation of the Voting Rights Act. You are disenfranchising a significant number of voters in Alabama. Go back and redraw those lines. Go back and do your work overall. Once again, your map runs afoul of Section 2 of the Voting Rights Act, which requires that states, when they are in fact putting together these maps, do it in a way that is not discriminatory. And so that is the decision that comes up now to the United States Supreme Court in this case called Merrill versus Milligan. It is also going to be argued this coming Tuesday before the United States Supreme Court. The case, once again, is going to revisit the Voting Rights Act, what that means, what that doesn't mean in America. You may recall well, we discussed it in this very program previously, a case called Brnovich that came out of Arizona in a previous term. Supreme Court substantially reducing the capacity of the United States Department of Justice and others to invoke the Voting Rights Act to remedy these kinds of problems. And so once again, the Supreme Court now taking up this decision by the lower court, the appeals court, that directs Alabama to rewrite its maps to ensure that the black populations in Alabama are properly represented in the lines that are being drawn. Again, much of that representative of what should be a representative government and representative population as voters of Alabama elect their representatives. And so we're going to chat about that more right after the break. Tell you a bit more about Merrill versus Milligan and a couple of other matters coming up before the Supreme Court. Stay with us for our final moments here on Morning Cannolis. About this important case, this environmental case called Sackett versus EPA. Supreme Court entertaining argument about that this coming Monday. Going to be determining whether or not the EPA can in fact enforce the Clean Water Act. What does it mean to be a navigable water? What are waters in the United States generally? How are they understood? And what is the discretion, the authority, the responsibility of the EPA to ensure that the Clean Water Act is enforced for our future generations? No small agenda there. That coming up for oral argument on Monday. On Tuesday, as we were discussing right before the break, the significant case involving voting and redistricting and gerrymandering in America called Merrill versus Milligan. Merrill versus Milligan, oral argument on Tuesday of this coming week. Right before the break, I described the predicates for it. That is the Alabama legislature drawing these lines based upon the 2020 census that basically disenfranchised significant numbers of black voters in that state, coming up from the Court of Appeals, directing the Alabama legislature to redraw those lines, do a better job. And in February of this past year, the Supreme Court, the United States Supreme Court, already touched on this case a bit, voted 5-4, a very split Supreme Court at that time, to reinstate Alabama's congressional district map, basically overturning the Court of Appeals, at least for the 2022 elections, the coming ones that are coming up just in November. And so it basically took the Court of Appeals decision and said, we're going to affirm that for now, but it said that it's going to decide down the road whether or not the particular congressional district maps that were designed by Alabama should become permanent after this coming election. So this is a big issue not only for Alabama, but for the entire nation as we get direction now from the Supreme Court coming out of the Court of Appeals, but the Supreme Court on what the Voting Rights Act says and does not say. So let's talk a little bit more about the predicates for this upcoming decision in Merrill versus Milligan. In a case called Thornburg versus Jingles, The Supreme Court previously said this, and some of this sounds very much in the weeds, but the upshot is the Supreme Court had previously embraced and applied a process for determining whether or not a racial minority, other minorities were in fact disenfranchised by virtue of gerrymandering line drawing. They said this, that plaintiffs in those cases have to show that enough black voters live in close proximity to draw a second or a third or a fourth majority black district. In other words, where are they physically located in the state? If in fact they are located in ways that would permit you to draw a principally black district, you can do that. And that would support the notion that the plaintiffs have a right to that kind of district being drawn. And second, that white Alabamans in this particular case would vote as a block for candidates who are generally opposed by voters of color. In other words, can you also show that likely black voters would vote for black voters and white voters would vote for white voters in such a way, white candidates rather, in such a way that you could anticipate some further representation in the United States Congress by people of color. In other words, there's got to be an analysis here of the extent to which new line drawing would in fact accomplish what you want to do, which is ensure that there is some sense, a good sense of racial parity and racial fairness when it comes to our elections. The reason why Thornburg versus Jingles is very important is that the state of Alabama is now advocating that standard, that analysis, that looking at exactly what could happen if in fact lines were drawn differently, that be discarded by the United States Supreme Court. The state of Alabama here is urging sort of a complete rejection of that traditional standard, been around for a very long period of time, and they're advocating instead this new test, and here it is, that a map should be invalidated. Alabama's map, for example, invalidated only if the new map, its configuration, can be explained only by racial discrimination. Let me say that again. But the test that they're advocating for is that a map would not survive only if its configuration can be explained exclusively by racial discrimination. In other words, if there's only a showing, if there is a showing of racial discrimination, that is the basis upon which the map would be disqualified. And of course, if you can come up with other theories upon which your map can be justified, that would in fact do it. And so once again, this new test that would invalidate a map only if its configuration can be explained exclusively by racial discrimination. If there are other motives for doing it, those would be sufficient. The maps would then be approved under this new standard, replacing Thornburg versus Jingles that has been the standard for many, many years in America. Why is this important? Why even if all of this legalistic standard approach sounds very, very thick and almost inaccessible, nonetheless, why is this important? Because the Supreme Court this coming Tuesday is going to be hearing our oral argument on this matter, determining probably not until June of next year exactly what to do with Alabama long term. We know again that the maps will stay in place for 2022, but we know as well that whatever happens comes out of this Alabama case, whatever the Supreme Court decides when it comes to Merrill versus Milligan, this is going to have implications for redistricting and line drawing throughout the nation. Not only for Alabama, but for states like Wisconsin and California, Pennsylvania, every place in the union is going to be looking to the Supreme Court to determine whether or not their own line drawing, the maps that are being put in place around the country, do in fact pass constitutional muster. Less important as we go ahead with more elections in this decade, but hugely important for the future. The next census, plainly, in the year 2030, and the new line drawing coming up in 2031. That sounds like a long time away, but plainly there are going to be objections to elections and voting during the course of the next several years. Merrill versus Milligan is one of these cases going to define what voting in America is all about. Do people of color have a right to be represented in the United States Congress, in this case the House of Representatives, by voting? Can they go to the polling places and anticipate that they will in fact be represented in a way that does reflect the makeup, the composition of the population there in Alabama and in other states throughout the Union? Hugely important, hugely important. Merrill versus Milligan, watch it for the coverage of that oral argument this coming Tuesday before the United States Supreme Court. And as we begin to wrap up our discussion here, know that in the future we're likewise going to be talking more about the Supreme Court. A regular part of our Morning Cannolis review. Come back with us next Saturday as we take up not only what the Supreme Court does on these cases, but we'll talk about future cases as well right here on Morning Cannolis. Thank you so much for joining me this morning. WAUK Waukesha, the Shaw in downtown Waukesha. Have a good week, everybody.
People started walking. There's a new kid in town.
You are listening to WAUK.